One is the fact that you are a head of state or a premier or whatever cannot affect your status as a lay litigant, in the sense that when Mr. Zuma was being processed, to put it mildly, by this court, the idea was that he had disobeyed a court order. And that would apply to whether you're a head of state or a sweeper or whatever. It applies to you. The second issue is this. The test of the reasonable litigant is not tested like that. And even if it was, let's say for argument's sake, Justice Campbell, that was the case with Mr. Zuma. What about the MK party? The MK party was not a head of state. But it's a litigant in front of you. And the MK party's perception is that this matter, because remember, it was after all the MK party that was in front of the Justice Pillay panel. It was not so much Mr. Zuma. So that is a litigant as well. And to suggest that the MK party was a former head of state would be stretching it a little bit.
And Mr. Mpofu, I specifically referred to the second respondent.
Yes.
Because I understood from the affidavit filed yesterday that the first respondent has distanced itself from the second respondent, and the first respondent has indicated that it will abide the decision of the court. That's why I specifically focused on the second respondent.
Yeah, no, firstly, there's no such thing as the first respondent distancing itself. A certain Mr. Jabulano Khumalo, without, as the Deputy Chief Justice explained, without putting any proper papers, has put an affidavit to say that Mr. Zuma's claim to the presidency of the MK party is false. But you can go through all these papers and show me where do we say Mr. Zuma is the president of MK party. You won't find it. So what has that got to do with what we're busy with here? That's just an unnecessary distraction and publicity seeking. So let's please not be distracted by that. But assume, for argument's sake, that he's right, and therefore the only litigant in front of you is the MK party. My answer still holds. So I don't see how on earth it could assist the assessment of this question, even apropos the MK party only. In fact, it's even worse, because against the MK party, the proposition that you are putting, Justice Campbell, of head of state doesn't apply. So it makes it our case even easier if it's just the MK party.
One last one for now from me, Mr. Mpofu. In chambers, you indicated that you might want to oppose to Mr. Ngcukaitobi's participation in this application, because as far as you're concerned, they are not before court. Do you want to address that aspect now or in your reply?
Yes. Sorry, I didn't hear the last part.
I was asking if you want to address that now or in your reply.
Well, in my reply to Mr. I can't, because I can't be replying to him if he has not spoken.
The horse would have bolted.
Yes. No, Justice, I don't want to make a big issue out of this. But, you know, we can't litigate like this. I know it's an urgent application and all that, and all of us have been fielding all the directions from the Honorable Deputy Chief Justice. But we served a notice of counter-application on, I think, the 3rd of this month. And in it, we said any party wishing to oppose must give us a notice to oppose by such and such a date. I think it was the 5th, and an answer by the 6th. No party did so. You know, a notice of to oppose is the simplest thing for an attorney to do. They can do it in their sleep. Just say, I'm going to oppose. Even if they don't even have to put an answering affidavit. By the way, that's what we did with the amici, if you remember, Deputy Chief Justice. We just filed notices to oppose. And we said we'll argue that matter on their papers. We didn't file any answering affidavits. But that's how litigants are supposed to behave. Because we needed to notify the court and the amici that were opposing their application. Otherwise, they would have come here in the casual belief that nobody is opposing their applications. And that's exactly what the IEC has done. It ignored the notice. It ignored the injunction to do an answering affidavit. It put some slapdash two-page thing in their heads, which is wrong, by the way. It's factually incorrect because it says that in the Hlophe matter there was the list did not include merely appearing, which is just wrong. So, you know, as I said, I don't want to be difficult. I'll leave it with the court. But if the example that is being given there is that there are litigants who can just rock up here and want to address the court when they have not done what you've asked of Mr. Khumalo's representative. Where's the notice? Where's this? Where's that? And then, if that's what it is, that's what it is. We'll have to live with it, but it is wrong. We want to register that there's no excuse for not filing a notice to oppose at the minimum, at the bare minimum, since that date till today. And therefore, if the rules are there to be obeyed, then such a party should not be given an audience. Because we don't know. We really, if I reply to what?
Is that approach overly technical, though? You yourself has pointed out that it's an urgent application, and I think it may be a bit unfair to compare the commission to Mr. Khumalo. The commission is a party.
Well, that's even worse with respect. If it's a party, then it means it was served with the notice that I'm talking about, unlike Mr. Khumalo. It was served with the counter application, and it ignored it. I mean, Deputy Chief Justice, just imagine this in the High Court. I put an application, nobody opposes it, nobody puts a notice, urgent or not urgent, and then I come to the court and I find that there's a counsel to oppose it. How can the administration of justice work like that? And it's not a technicality. If it was a technicality, then it must be removed from the rules. The obligation to notify parties that you are opposing a matter must be removed because it's just a mere technicality.
Right.
It's not a technicality. It's part of audi alteram partem. It's the fact that you must know that somebody is going to oppose so that you can prepare on that basis. It's a very fundamental right. It's part of Section 34 of the Constitution. If we have to go that far.
You have made your point, Mr. Mpofu.
As court pleases.
Would this not be a good time to take the chair adjournment?
As the court pleases.
All right, we'll take 15 minutes until 12:05.
15 minutes, thank you.